Hi, my name is John Landy. I am a retired law professor at the University of Missouri Law School, and I'm recording this video primarily for law students, but also for lawyers to help understand techniques for litigation interest and risk assessment, which are fundamental techniques for any lawyer in litigation and a variety of other contexts. It's based on a book that I co-authored with Michaela Keat and Heather Haven called Litigation Interest and Risk Assessment: Help Your Clients Make Good Litigation Decisions. It's a practical guide with checklists. It combines research on risk assessment and early dispute resolution. It's primarily written for lawyers representing clients, but it also has material for mediators. And if you want some more information about the book or to order it, you can go to this website, a tiny URL, YBC50 or 50U68. You'll see that there's a link there, and this PowerPoint includes lots of links, and you can have access to the PowerPoint, which will provide all the links afterwards. So I'm going to start off by describing a new study that recently came out that was conducted by Ohio State law professor Deborah Jones Merritt, along with the Institute for the Advancement of the American Legal System. And it was based on a study of 50 focus groups of new law graduates and lawyers who supervised them. And here are some excerpts of quotes from some of the lawyers they interviewed. And one of them said, the number one complaint from clients of lawyers is lack of communication or poor communication and not being told what the hell is going on in their case. This is a problem, and actually all of these are not just for new lawyers, but many lawyers who have been practicing for quite a while. One of the most common bases for disciplinary complaints about lawyers is failure to communicate with clients. This is a really important thing for lawyers to do. Another lawyer said, someone can know the black letter law inside and out, which is what we teach in law school, and then their first day on the job, they're sitting in front of somebody who is incredibly worried, incredibly anxious, and they don't know how to handle that. Just knowing the black letter law doesn't answer the question. And sometimes we don't ask the client, well, what does victory look like? What's your goal here? And this is really critically important. We may assume that we know what the goal for clients is, which is to win, to get the most favorable financial settlement, but that may not be their goal or their primary goal. And a supervisor described that failure to understand the big picture created difficulty by lawyers in developing strategies to guide client matters. These new lawyers knew the rules, but they didn't know how to combine the rules into a successful strategy. And that's really what this LIRA approach is about, is to think holistically, to think strategically, to be able to help your clients. So particularly for law students, but also for practicing lawyers, the study emphasized that law students need to engage in continuous self-directed learning. Now, this is for law students, but of course for practicing lawyers, you're probably required to engage in some continuing legal education. And you should do that probably beyond the minimum required by your state bar. And for law students, you won't learn everything you need just by completing all the graduation requirements or taking the bar. That's just a minimum, and it doesn't teach you about all sorts of important things, particularly working with clients and negotiating. And what you learn in the law is like a rule book for football or other games. It gives you the rules. It tells you what you can and can't do, what will be called for a foul, but it doesn't tell you how to win, how to play a real game. And you really need to learn how to deal with clients and to get the big picture. And to do this, they recommend taking clinical and externship courses and develop your own learning plan. Figure out what it is that you want to do after you graduate and what you need to do to prepare yourself as well as possible. And here is a link to a blog post that provides more detail about that. Now, lawyers have ethical duties to help clients make decisions. This is actually lawyers' basic fundamental role, and it's embodied in the ethical rules under the Model Rules of Professional Conduct published by the ABA, but most states have, or virtually every state has, similar or identical rules as these model rules. So the model rules say that lawyers have to provide clients with relevant information. They need to provide understandable explanations, candid advice, and recognize that clients have to set their objectives for the representation, and it's up to lawyers to abide by their clients' objectives and to abide by clients' decisions about whether to settle or go to trial. So the most fundamental decisions in a case are made by clients, what the goals are and whether to go to trial or to settle. And in order to be able to make those decisions, lawyers need to provide relevant information, understandable explanations, and candid advice. It's very tempting for lawyers to tell clients what they want to hear, but that's not what clients need, and it's not what lawyers are required to do under the ethical rules. So what this LIRA system is designed to do is to help lawyers improve party decision making. It fulfills fundamental ethical obligations that I've just described, and importantly, it's designed to improve results for parties, for courts, and society. Part of this is by reducing what researchers call decision errors in going to trial after parties reject a good settlement offer. Shockingly, something like 85% of cases that go to trial, one side or the other rejects an offer that is better than the result at trial. So if you're representing a plaintiff and the defendant is offered to settle for $100,000 and you go to trial and receive a judgment of $50,000, this is a horrible result. Your client is getting $50,000 less than she would have gotten if she accepted the defendant's offer, plus she's expended all the time and effort and expense of continuing litigation and going to trial, and all the stress that's involved, and she's probably not very happy with you. She would have been a lot happier if she would have accepted the settlement offer. And this is true for defendants as well as plaintiffs. So if a defendant ends up paying an awful lot more than plaintiff's demand, this is not a good result. And it's bad for not only parties, but also for courts and society. Courts have limited resources, and it's a waste of courts' resources if the parties could have reached a better outcome without going to court. And of course, courts are funded by society, and so it's important to use our limited resources well. And part of what this LIRA system is about is reducing the tangible and intangible costs of litigation. So why do people make bad decisions? Well, there are a ton of biases. People make cognitive and motivational errors due to self-serving, confirmation, hindsight, sunk cost, partisan role biases, anchoring, and reactive evaluation. What are these things? Self-serving bias, just as it sounds, is where people are assuming that they're doing things better than other people and that other people don't deserve as much credit as they would if they were giving it the credit to themselves. Confirmation bias is where people look for and pay attention to things that support their point of view and ignore or discount things that are inconsistent with their perspective. Hindsight bias is when people assume that in the moment people should have or did understand things the same way you look at it in hindsight. Sunk cost bias is a very common one in litigation, where people, after they've invested a lot of time and money in litigation, feel that they have to carry on because they've invested so much already. It's an understandable emotional reaction, but it's a very poor way to make decisions. There's no way of getting the time and money back. The best you can do is make the best decisions you can going forward. Lawyers have partisan role biases. They take on the biases of their clients. So lawyers representing plaintiffs tend to have the same biases as their plaintiff clients do, and the same for defendants. Anchoring is another bias where people focus on certain things, often the first thing that's mentioned. So plaintiffs, and for example, if you file a complaint and you're asking for $1 million, and and you may tell your client that there's no way that he's going to get $1 million in trial or settlement, but he has that $1 million figure in his mind, and that affects his decision making and the way he feels about the process. And reactive devaluation is a process where people discount things from adversaries where they would consider them more positively if they heard them from a neutral party, such as a mediator. So these are just some of the biases that affect people's judgments, and they almost always encourage overconfidence, which then leads people to make these decision errors to go to trial when they would do better to settle. Another reason that there are bad decisions in litigation is because of dynamics of lawyer-client relationships that produce what we call the conspiracy of optimism and prison of fear, which inhibit candid assessment. When lawyers and clients first meet, both are generally inclined to be overly optimistic. Clients tend to want to put the best face on it, to have the lawyers agree to accept their case, to not have the lawyers think poorly of them. And conversely, the lawyers tend to want to retain, to get the case to be hired and to maintain the confidence of the clients that they're going to fight hard for them. And the opposite, the flip side of that, is the prison of fear, where lawyers and clients are afraid to acknowledge things candidly. They're afraid that it will inhibit confidence of the lawyer or the client or the other side, and they're afraid that the other side will take advantage of them. And a third reason for bad decisions is reluctance of lawyers to communicate clearly and specifically about litigation risks. One of the problems is that it's impossible to know what the outcome of a trial will be. You may be reasonably confident, but even there, you just never know. And it's hard to predict. Lawyers may say, well, you have a good chance of winning, but what does that mean? Does that mean a 51% chance or a 99% chance? I mean, if you tried the same case 100 times, you wouldn't get the same result every time. You'd have something that probably looks like a normal distribution curve, and most of the responses, most of the outcomes would be centered around the average, but they would range above and below the average. And it's just very hard to communicate that. And so lawyers sometimes talk about it vaguely, and sometimes they go to the other extreme and provide so much detail in writing or orally that clients can't figure out how to make sense of that. So this LIRA system is designed to help clients to understand their interests in litigation risks clearly, to identify key legal and factual uncertainties, to estimate possible court outcomes, and then to develop bottom lines for negotiation. This involves explicitly considering tangible and intangible costs of litigation, and it's designed to help clients develop wise and effective strategies for litigation, negotiation, and mediation. So how do you do it? You start off with really basic legal skills of asking good questions and listening carefully. These are basic, but they're hard, and a lot of people don't do it well. And it's something that every lawyer really should be focusing on, is asking good questions and listening carefully. And part of your job is to figure out what the dispute really is about and do this jointly with a client. And you shouldn't just assume that the dispute is about the correct interpretation of the facts of the law. That's what people argue about in law school. That's what we train you to do. And that's an important part of it. And that may be what clients are concerned about, but often they're concerned about other sources of conflict and other problems. And so your job as a lawyer is to be a conflict diagnostician. And you can do this by asking questions like, what's most important to you in this case, or why haven't the parties settled so far? Those will give you some good clues. And people often want things in addition to financial outcomes, things like being treated with respect, having good relationships, favorable precedent, getting apologies, having future employment or recommendations. So finding out what your clients really want is important. And figuring out what the sources of conflict may be. And often they're due to conflicts in relationships. People are getting along well, they would work things out. But if they're not, all of a sudden disputes arise. They don't trust each other. They have poor communication. They're afraid of looking weak and losing. They're concerned about setting a precedent for the future. Sometimes you have conflict because lawyers act adversarially to perform for clients and to increase their fees. And sometimes it's because people have unrealistic expectations about the trial outcome. Notice that there are a lot of sources of conflict beyond expectations of the trial outcome. And it's important for lawyers to pay attention to and figure out what the conflict really is about. Part of this involves understanding the other side and helping your client understand the other side. So you might ask clients what they think the other side's perspectives and goals are. Now, this can be a challenging thing to ask because clients may be afraid to acknowledge that the other side has some merit to their point of view. But if you develop a good relationship with your client, you can get them to be more candid about this. And then you can ask if they think that any of the other side's perspectives or goals are justified. And you can follow up by asking if this affects their assessment of the likely court outcome. So if the other side has some merit on their side, then this may make your client more realistic about what might happen if they went to trial. And then you can also ask them about what might persuade the other side to change their assessment. Most cases in the United States are settled. And when you have negotiation, typically one side or the other, or usually both, will change their assessments to reach some agreement. And part of what your job is to try and persuade the other side to change their assessments. One of the things you can do is ask the client about how the case has affected them so far. This can be a good indirect way of finding out their interest. Very few people enjoy litigation. Generally, they will complain. And that's a very useful way to find out what's on their mind and what's bugging them, and to find out what will help them stop hitting their head against the wall so that it feels so good when they stop. So you can ask how you can be helpful. And you shouldn't assume that they just want you to tell them what they want to hear. Sometimes they do, but if you develop a good relationship, they'll be interested in hearing other things. They may want your candid assessment of what's likely to happen if you went to court, an understanding of the other side's views, advice about litigation or negotiation strategy, or other things. So the lesson here is don't assume, ask. Ask your client, and ask in a way that tells them that you really want to know what they want. So this LIRA system has three elements. The first is the expected value of the court outcome. You may be familiar with the term BATNA, best alternative to a negotiated agreement. And in the litigation context, usually the BATNA is what would happen if you went to trial. Second element are the tangible costs of continuing to litigate. Third element are the intangible costs of continuing to litigate. And I'm going to talk about all three of those. Note that this process can and should be used before lawsuits are filed, although we talk about the litigation interest and risk assessment. Lawyers can and should do this from the very beginning and before filing lawsuits. Our book focuses generally on monetary disputes, but these techniques can be used in non-monetary issues. And it focuses on future costs, not past sunk costs, because you want to avoid that sunk cost bias. So let's talk about these three elements. The first one is the potentially unfavorable court outcome. Now, litigation is an incredibly important mechanism in our society that provides an incredible range of benefits to parties in society. And I'm not going to go into all of them. Presumably you're aware of most of them, but it's important to begin by acknowledging that, and also recognizing that litigation is inherently risky and parties may get unfavorable court decisions, which is one reason why they often settle. And so, and parties' expectations about court outcomes often are major factors in negotiation and mediation. So if you have a plaintiff who thinks that we get $100,000 at trial, she may say, there's no point in me taking $20,000 or $50,000 in settlement because I'd get so much more in trial. So their expectations about the court outcome affects the way they go about negotiation and mediation. Tangible costs include legal fees for represented parties and legal expenses for discovery and experts and things like that. These can be quite substantial, and these are things that obviously affect what the net benefit to the clients are, and these are things that clients often are very concerned about. Then you have intangible costs. And being a party in litigation imposes many intangible costs on parties, such as litigation stress, which causes literal physical and psychological harm to clients. Feelings of unfairness, disrespect, and victimization. It's just so unpleasant. People are attacking you. They're disrespecting the clients. Clients typically feel that what's happening is unfair to them. They're feeling stuck in the process. They're not getting on with life. They're not getting on with their business. It damages relationships. It harms their reputations. It can cause them to lose opportunities. They invest time and money and effort into litigation that they can't invest in other things. And the litigation, I mean, if you look at these intangible costs, even if you win, even if you get every possible remedy as a plaintiff, or even if you win as a defendant and the plaintiff gets nothing, you still have all of these intangible costs, which are extremely potent, and they're intangible, but clients feel them intensely, and it's important to pay attention to them. And they're important because they're very important to clients, sometimes more important than the court outcome. And people often ignore or undervalue intangible costs, which reflect parties' interests, and lawyers often ignore or undervalue intangible costs. And these, part of your job is to help your clients advance their interests, and these intangible costs reflect their interests. And it's also important because this may reduce their expectations for monetary outcomes, making it easier to settle. So a plaintiff who thinks that she might get $100,000 at trial might be willing to accept $80,000 or $90,000 to avoid all the stress and anxiety and risk of going to trial. So paying attention to the intangible costs can have a very practical value for lawyers in helping their clients. So how do you discuss intangible costs with clients? There are a number of ways of doing it. One is you can just ask. You can say, well, earlier you said that relationships were important to you. How would going to trial affect your relationships? Or you can coach them. When I see people late in litigation, they often say it has taken a toll on them. So you're normalizing, you're saying not just how this particular client is doing, but how clients generally, in your experience, have managed. You can delegate. You can say, please discuss with your spouse or your boss or someone else how going to trial may affect you. And you can tell them, you can say, going to trial is likely to hurt your reputation and keep you from doing the things you want to do. So there are lots of ways that you can discuss with intangible costs with clients, and you may combine a variety of them. And then the tangible costs of litigation. You can discuss how much money they've spent so far in litigation fees and costs, and then do your best to estimate how much they probably would spend to go to trial. This is really difficult. It's very hard to not only to predict the court outcome, but to predict how much the legal fees and expenses are going to be, in part because it depends on how much the parties want to fight. And that's hard to know in advance. So you won't have exact figures, but do your best to give a range, and you can use round numbers, and also explain that you can't predict exactly. And then assessing the likely trial outcome, which we suggest you do after asking clients about their interest. And you can tell them that research shows that in most trials, one party is unrealistic, and gets worse results than in settlement. And then you can say, do you want to have a realistic assessment? If you ask them that, most clients will say, yeah. They won't say, no, lie to me. And so that will give you the permission to be candid with them and have a good analysis. And you can tell them that you're confident that you could persuade the court about some issues and less certain about others. And you can discuss the uncertainties and how you would address them. And based on this, you can provide a realistic range of likely court outcomes, recognizing that, again, if you were going to try the same case 100 times, you get a variety of different outcomes, and you may be more or less confident about that range. So how do you develop your estimates? Well, lawyers who have experience with similar cases will use that. Obviously, the legal research and discovery that law students are trained in will help identify similar cases and give you some precedents that will give you guidance. Consulting with other lawyers, certainly new lawyers should do this, but lawyers with a lifetime of experience will consult other lawyers. There's a technique called using decision trees, which involves identifying contingencies, factual and legal uncertainties, assigning probabilities to them and the values of the outcomes, and then combining them mathematically to come up with mathematical estimates of the likely court outcome. And then increasingly, there are big data and artificial intelligence tools that will help make estimates about what the likely court outcome might be under given circumstances. And the choice of method will depend on many factors, especially the amount at stake, the lawyer's experience, and the client's preferences. Obviously, the more at stake, the more it makes sense to invest time and effort in trying to estimate the court outcome. In discussing trial with clients, there are a variety of ways of doing it. You can identify the risks by saying something like, in trial, many judges would be concerned about this issue. You can quantify the risk. I think that the odds are 2 to 1 that the judge would decide this way about this issue. You could predict the outcome. I think that most judges would decide this way about this issue. So to come up with an estimated outcome, the book provides a framework using the logic of decision trees for estimating a mathematical value of the court outcome. Combines the process into a few steps, estimates the probable resolution of key legal and factual issues, explicitly includes the intangible and tangible costs to generate a bottom line for settlement, and you can vary assumptions to develop this range of likely court outcomes. So how does the simple framework work? Well, there are 2 stages. The first stage is to estimate the court outcome. You estimate the risks regarding liability in terms of a percentage of probability of establishing liability. You estimate the damages, and then you estimate the court outcome by multiplying step 1 by step 2. So let's just say you think that there's a 75% chance of the plaintiff establishing liability, and if she does, that she would get $100,000 in damages. You multiply 75% times 100,000, and you come up with an estimate of a court outcome of $75,000. Second stage involves calculating the bottom line. So you estimate the tangible and intangible costs. With the tangible costs, that's out-of-pocket money, and you can think about dollar values. For intangible costs, you want to ask the clients how much value they place on the various issues that we talked about. So you estimate these costs, and then you deduct them from the estimated court outcome. So if you think that estimate the court outcome in step 3 is $75,000, and you estimate the tangible and intangible costs as $15,000, then the bottom line would be $60,000. What that means is that if the plaintiff can receive anything more than $60,000, she would be better off than going to trial, considering her expectation about what would happen at trial and the tangible and intangible costs of getting there. So in using the bottom line is a tripwire to end negotiation if the parties can't reach agreement. So this $60,000 that I just mentioned is a figure that the plaintiff can use so that if she receives offers less than $50,000, she'll say, okay, it's not worth it to me to settle, I'm going to go to trial. And if she receives more, then she knows that it's okay, it's in her interest to settle, to reach an agreement. And the bottom line is a major element in negotiation strategy in the counteroffer negotiation process. Often what happens in civil litigation is each side will start off with an extreme position and then make a series of counteroffers. So if the plaintiff thinks that $60,000 is her bottom line, she's not going to start off with a demand of $60,000. She may ask for $150,000, and the defendant may offer $10,000. And they'll have a series of offers and counteroffers, and the plaintiff is going to try and end up with a settlement over $60,000. And to develop the strategy to do this, she'll need to know what the bottom line is so she knows where to start and how to make her series of concessions. The lawyer is a dispute system designer. People often think about dispute system design for a series of disputes, but lawyers design disputes processes in individual cases, orchestrating exchange of information and legal procedures. And the LIRA process provides more and better tools to plan optimal decision-making, to accommodate parties' process needs, to plan the timing and sequence of the process, and to use mediation or other dispute resolution processes when available. So to sum up, to plan and conduct negotiations, it's a process of mutual education of lawyers and clients, realistically assessing the other side's perspective, developing a bottom line, developing a negotiation strategy, planning the logistics for negotiation, considering using multiple sessions. This is especially important now in the wake of COVID, where people are not getting together in person and they aren't necessarily expecting to do a negotiation all at once. And having multiple sessions can improve the decision-making process in many ways. Consider using mediation, which I'll talk about more, and pay attention to what's working and what's not working. And if things aren't working, modify your tactics as appropriate. So mediation. Sometimes parties need help from a neutral third party. Part of the benefit is that the neutral organizes the process systematically. If you just have two lawyers who are in an adversarial relationship, they may try and get some advantage from the procedure, and that creates unnecessary problems. Neutral third parties can organize the process systematically and in a way that people consider fair and accept and avoid unnecessary disputes about. Mediation provides a settlement event where everyone is focusing on negotiation. Mediators can provide independent help to help each side do their LIRAs, and it can avoid problems of reactive devaluation because the other side suggests ideas. So mediators can raise ideas with each side, and people may be more willing to consider the ideas if mediators raise them than if the other side does. Now, you can break this down into two stages, and this is an alternative to the common norm of trying to complete mediation in a single session, especially in civil mediations. And this single session process puts great pressure on parties to settle before they are ready, especially in marathon mediation. Some mediations go on well into the evening and late at night, and that is not good for decision making when people are tired and they reach agreements just to get the process over with. And this can result in bad results. Buyer's remorse. Parties may renege on agreements that they made late at night. They may not perform the agreements well. may stimulate complaints against mediators or lawyers because they feel forced into agreements they didn't really want to make. And you can improve the process by suggesting the option of a two-stage mediation so parties can consider LIRA issues after the first session. So how do you do it? People settle in the first session, great. They don't need a second session. If they don't settle in the first session, they can do homework to prepare for the second session to consider the three elements of LIRA, the expected court outcome and the tangible and intangible costs. And planning for the possibility of a second session gives people permission to take the time to get information, consult others, and to refine their goals and their strategy. And you can even expand it to multi-stage mediations. So again, taking advantage of the virtual mediation process, you can break the mediation into multiple stages during a particular period, such as a week. And this has the benefits that since people aren't traveling, they don't have to be together all at one time. And in particular, in the mediation process, there's these caucuses, these private meetings where the mediator meets with just one side at a time. And there's this dead time where the mediator's meeting with the other side, and these caucuses can last an hour or more. And one of the virtues of multi-stage mediation is planning for authoritative decision makers to participate for limited times as needed. So when you have cases involving large corporations, the top executives typically are not going to attend the mediation, and that can be a problem because they're needed to make these final decisions. But with a multi-stage mediation, you can have them participate as needed, often at the end of the process, and sometimes at the beginning as well, or whenever it's needed. Now, the LIRA process that we describe in the book focuses on civil cases, but you can adapt these concepts for criminal cases. So in criminal cases, you want to anticipate what the court outcome would be, which may involve the length of sentences, the amount of fines, whether the sentences will be served consecutively or concurrently, whether the defendants would get probation, and if so, what the conditions of probation would be. So you want to think about what is likely to happen if you went to court. And then you want to think about the tangible costs, which may differ for defendants with private counsel and those represented by public defenders. Those with private counsel, obviously, you're going to be paying the lawyers out of pocket for their fees. For public defenders, they aren't paying attorney's fees, but there may be administrative and other costs that the clients need to pay the defendants. Prosecutors have limited resources for their entire caseload, so although they're not paying for lawyers' specific time for each case, they cannot afford to try every case, and so they have to make calculations as to which cases are worth going to trial for. And then thinking about intangible costs and interests. Defendants may be concerned about harm to family members, losing jobs, and a whole variety of collateral consequences of being convicted. And these are really important interests that defense counsel really need to talk with clients about. Prosecutors have a whole variety of intangible concerns, including consistency with similar cases, their feelings of justice, policies in their office, concern about the impact of the crime on victims and impact of the settlements on victims, the prosecutor's reputation, the potential for publicity, and effect on their win rate. So lots of different intangible considerations go into thinking about how to handle criminal cases. Now, this process also can be adapted for negotiating transactions. So if you think about negotiating deals, the outcomes are the net profits, which from various plausible options, which can be affected by a range of factors such as the availability and terms of financing, the diligence of contracting parties, the production efficiency, consumer reaction, market competition, and government actions, among other things. So part of what the parties and lawyers need to do is to anticipate what would likely happen if they proceed with a transaction, much as lawyers in litigation need to anticipate what would happen if they go to trial. And then there are the tangible costs of negotiating and consummating deals. And then there are intangible benefits. Typically in these transactions, you're focusing on benefits which may be generated from the transactions, which may include improved public image, development of business relationships, expansion of markets, and increased technical capabilities. There are also risks, which include lost opportunities to pursue other transactions and possible dysfunction or damaged relationship if the deals blow up. The book includes a whole bunch of helpful appendices, including lawyers' interview guides about clients' interests, clients' litigation interests and risks generally, and for family law cases, a series of appendices about doing these mathematical calculations, and some advice about self-care by practitioners. Working as a lawyer is extremely stressful in and of itself. Lawyers often struggle with mental health issues and substance abuse issues, and it's really important that lawyers take care of yourselves so that you live happy and healthy lives, that you can be in condition to help your clients as well. Finally, let me mention some resources that you might want to take a look at. There's an article by Clark Cunningham, which collects studies about how clients feel about lawyers, which, spoiler alert, not very positive in many cases. Clients often are very frustrated with their lawyers, in part because lawyers often don't listen to them, as described earlier. There's a book by University of Cincinnati professor Marjorie Corman Aaron called Client Science: Advice for Lawyers in Counseling Clients Through Bad News and Other Realities. As described before, often the bad news is that you have to give bad news to clients. This is a difficult, sensitive process. This book provides empirically based advice about how to do that well. There's this article that I wrote, Good Pretrial Lawyering, Planning to Get to Yes Sooner, Cheaper, and Better. And this is based on interviews that I did with lawyers about how they settled their cases. I wrote another article, particularly for, again, law students and also lawyers, my last lecture. I wrote a book, Lawyering with Planned Early Negotiation, How You Can Get Good Results for Clients and Make Money, which are two major interests that lawyers have. Here's a blog post with more information about LIRA. I blog on Indisputably, which has more information periodically. And here's my email if you'd like to email with me or talk by Zoom. I hope you found this valuable, and I hope you have a very successful career as law students and lawyers. And with that, I'm going to bring this to a close.